So good afternoon and welcome everyone. My name is Catherine Williams and I'm, as I said, the Centre for Public Integrity's Research Director. I want to thank you for joining us today from wherever you might be joining. I'm joining you from the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present. I also extend that respect to Aboriginal and Torres Strait Islander people participating today as we discuss a momentous occasion in Australian history, and that is the introduction into the Federal Parliament of the National Anti-Corruption Commission Bill. Geoffrey Watson SC, who is with us today, described last Wednesday, the day of the bill's introduction into the Parliament, as a grand and golden day for Australia, and perhaps he can shortly explain to us why that is. But the fact that experts have welcomed the bill certainly does not mean that they have given it their unconditional imprimatur. Unsurprisingly, for such a complex piece of legislation, there are aspects of it requiring refining as well as aspects of it requiring substantial amendment. To talk us through the bill today, we are joined by the Hon Anthony Whealy KC, the Hon Stephen Charles AO KC, and Geoffrey Watson SC, who I'm sure are well known to all of you. They are three integrity advocates who have played a significant role in getting us to this point where we are so close to finally seeing the establishment of the Integrity Commission that Australians want and deserve. Now, on an administrative point, we are going to run this session today as an actively chaired session. So if you have questions that you'd like to put into the chat, please do put them in and we'll try to have them addressed for you as they're relevant to the conversation. So in order to get us started today, I thought I'd ask you, Geoffrey Watson, about what it is that made you describe the introduction of the bill into the Federal Parliament last week as a grand and golden day for Australia.
Well, we've been waiting for it for so long. It's not widely understood, but when you think about it, you realise I'm right when I say that public sector corruption is the most serious crime on the planet. The international drug trade would wither and die without public sector corruption. We are signatories. Australia is a signatory to United Nations Convention to prevent corruption. We do that not just as a legal matter, but as a moral matter, because corruption, public sector corruption, causes death. 20 to 40% of all aid sent to Africa is simply stolen. Now, what's that got to do with our bill? Well, we signed up to that treaty and said that we would create an agency like this. Arguably, we've been in breach of that arrangement since 2005. Finally, we've got it. Okay, we got it, and that was a political fight in its own right. I don't think that anybody could sensibly explain the coalition policy in respect of a National Integrity Commission. Mr. Morrison said he'd introduce one, but of course he'd said that before. Mr. Joyce, he sort of garbled out some words to the effect that he opposed it. So we would never have known, but here we are, we've got it. It's such a breakthrough. It's a critical component in the overall framework of integrity in Australia.
So as you say, a breakthrough, and it will be a critical component of the integrity framework as it exists. But also, I know it's the case from having seen your commentary in relation to the bill that there are some aspects of it that do need to be addressed. And one of those is what the bill proposes to provide in respect of public hearings. So, Stephen Charles, perhaps I could ask you to tell us about what the bill proposes to provide for public hearings and your view on whether this power is adequate or not.
The original proposal of the government was to have public hearings when the Commissioner arrived at a view that it was in the public interest to hold a hearing in public. And invariably there would have been lengthy hearings by the Commission in private, long investigations beforehand to arrive at a view that a situation had been found to exist where it was in the public interest to have the remainder of the hearing in public. Now, shortly before the matter came into Parliament, as far as we can gather, a proposal came in possibly from the coalition, although that hasn't been admitted, a proposal came in that they should introduce into the section, which is section 73, the words exceptional circumstances, which were to be necessary or to be found to be necessary before the hearing could take place in public. That's been brought in from the Victorian legislation for the ICAC, section 117, and that is something which the Victorian Commissioner, Robert Redlich, has been fighting to have removed from the Victorian Act for some years. Now, the government has refused to remove it. The difficulty with a necessity to find exceptional circumstances is firstly the ambiguity. No one knows exactly what exceptional circumstances are, and it's been found to seriously limit the number of public hearings that can take place. Victoria holds much fewer public hearings than does the New South Wales body. Now, most royal commissions take place entirely in public. The Hayne Commission on Banking took place entirely in public. Most of the Fitzgerald inquiry into corruption in Queensland took place in public. And there are very good reasons for this. There are several of them. It's so that the public knows what is going on, what has been discovered, what the nature of the investigation. The public can see that the investigation is fair. The public, once it knows what is being investigated, will that more evidence will be offered from members of the public. And above all, it will act as a deterrent to people who are contemplating acting improperly, that they may end up in public trying to defend their conduct. Now, the main danger with public hearings, of course, is damage to reputations. And it's important to remember that these only happen at the end of a long process of investigation and before the commissioner can decide to hold a public hearing. He or she must look at and be reasonably satisfied on questions which are set out in section 73, which would include whether there is danger of unfair damage to people's reputation, privacy and well-being, and whether potential witnesses have a particular vulnerability. The commissioner will have had to have thought about those matters and reached a proper state of mind on them before he or she can decide that there should be public hearing. Now, the potential damage to reputations is certainly there, but the examples that have been usually given of damage to reputation, people like Nick Greiner or O'Farrell or Berejiklian, really are answered by what has happened in each case after a public hearing's taken place. Mr. Greiner is a leader of the community in both in business and in politics. Mr. O'Farrell has been High Commissioner in India. Ms. Berejiklian, whose matter has not yet been concluded, unfortunately, but was taken straight into a senior position in Optus. The dangers of damage to reputation are overstated. Some occurs and they must be guarded against. But generally speaking, the commissioners of integrity bodies usually stress that these are essential to the task they are trying to carry out.
Okay, thank you, Stephen. So we know that public hearings have a vital role to play in the work of integrity commissions, and we've got this proposed limitation of exceptional circumstances in what I'm going to refer to as the NAC bill. So what would an appropriate solution be? And I raised in particular, someone emailed a question ahead of this webinar, and they asked, well, is one solution to eliminate the word exceptional and replace it with the word appropriate? And Anthony, I might ask you what you think about that.
Yeah, well, I do think that in exceptional circumstances is much too high a legal test. We don't quite know its content as a legal test, although there's been a Victorian case on the subject, which makes it appear that quite difficult to apply. It's got to be something that's quite out of the ordinary. So look, it is a really harsh test. And the additional point I would just add very briefly to what Stephen has said is that I believe that there's a specious circularity involved here, because on the one hand, you have a commissioner who has to consider, or would normally consider, very carefully whether reputation's going to be unfairly damaged. And having considered that and other things, then decides, look, we're going to have a public hearing. And then that commissioner, he or she, is met by a further test, exceptional circumstances. And the Attorney General has said the reason why there's that additional test is to protect unfair reputation to damage. And that's why I say there's a specious circularity about the process. So what can we do? Well, look, there are a few suggestions. I think that those considerations that Stephen referred to, including unfair damage to reputation, damage to privacy, etc., they could be made mandatory considerations, that the commissioner must look at those matters. But we've also got already significant protections by the presumption in favour of private hearings. And I think that considerations of that kind, there may be others, would be sufficient protection. But of course, this is probably a political decision to put these words in there. And I can understand why that's so, because I suppose the Attorney General and the Labor Party want this to be bipartisan. You can understand that. That's good politically and sound, really, but not at the expense of being able to hold public hearings where they're really in the public interest to do so.
And Geoffrey Watson, look, I might ask you, as a former counsel assisting the New South Wales ICAC, what can the consequences be for an integrity commission's work if it is forced to, it has a person and wants to hold a public hearing involving that person, and the person has the ability to challenge the commission's decision to hold the hearing in court on the basis of something like an exceptional circumstances requirement? What happens to the commission's investigation then? You're on mute, Geoffrey, I'm sorry.
People will be relieved to think I'm on mute. My answer was the proceedings would be disrupted and they would be delayed, and that is usually the purpose. During some of the inquiries that we had, there were repeated efforts made to try to prevent David Ip, who was then the Commissioner at ICAC, from continuing in an investigation which involved the OBs. It happened time after time. Now, what you'll find in these corruption inquiries is often the people embroiled in them have got a lot of money, and they don't mind going to court, even if they're going to lose, simply if it has the effect that it will disrupt or delay the continuation of proceedings. So it's awful. The potential for litigation arising out of exceptional circumstances was more or less brushed aside by Mr. Dreyfus, who I think, quite legally speaking, correctly said, it's very hard to challenge. Yeah, you only to challenge a decision of that kind made by the NAC only requires somebody with enough money to put on the statement of claim and make the application to court. I don't care whether it's going to win or lose. I just want to disrupt and delay.
So perhaps hard to win, but as you say, not hard to challenge. So this really is an area that we hope will be an area that is amended as part of the committee inquiry into the bill.
Can be done pretty easily. Just somebody give the Attorney General a black pen and a ruler, and he can put a line through it.
I think it's going to be hard myself, Catherine. I think politically this is going to be a hard one to shift. But we should all, I think, make our point of view clear on this and keep advocating for what was originally planned to be a public interest test and nothing more.
Well, could I just make the point, I'm sorry to labour it, but the Shadow Attorney General, Mr. Lisa, has now said that it's the coalition policy that the decision as to whether or not exceptional circumstances are present would be taken out of the hands of the Commissioner of the NAC and given to another person. He said an eminent judge. I don't know whether he meant a current judge or a retired judge, but it just introduces another person who has to be separately persuaded of the fact. The potential for disagreement and the compromise of the Commissioner's autonomy, well, that's obvious.
An entirely unworkable solution, that one from the start. Okay, Anthony Whealy, I just want to pick up on the point you made about areas where it might be hard to win amendment. And I want to talk about that in relation to jurisdiction, because I know you've done a lot of thinking about the proposed jurisdiction of the NAC. I'm interested to know whether you think that it is adequately broad.
Well, first thing to say is that a broad definition of corrupt conduct was promised in the Labor Party's modelling. And I think in general terms, we can say that there is a broad definition of corrupt conduct. It's a broad definition. It looks to see whether there's been any interference, either directly or indirectly, with honest or impartial exercise of any public official's power, or the honest or impartial performance of any public official's functions or duties. And there are other areas of the width of it as well, but that gives you an idea that it's very wide. Unfortunately, it's not quite as wide as it might be, and it's not as wide as the definition of corrupt conduct in most of the other states and territories. And I exclude there Western Australia and Tasmania. But in all the other states and territories, there is a wider definition. And it just seems to me to be a shame that in the federal sphere, where we're looking for best practice, we've suddenly got a narrowing of the definition so that it doesn't cover corrupt conduct by third parties where there is no wrongdoing by a public official. In other words, we're talking about serious criminal conduct by third parties which massively deceives those involved in public administration and reaps a financial reward for that dishonesty. That's not covered. And the Attorney General says, well, we're going to leave that to the police. And that's fine, but we know that the police do not have the powers of a Royal Commission or of an anti-corruption commission. And the trouble about corruption generally is that it's buried very deep. It's hard to unearth it. It's in dark corners, and you only get to unearth it by the use of special powers. That's why we have anti-corruption commissions. So to turn around and say, here's an area of possible serious criminal corruption that we're just going to leave to the police, I think is undesirable. And I think it's particularly undesirable because this type of activity seriously impairs the public's or the community's trust in the integrity of public administration. If they see this sort of serious wrongdoing by third parties go undetected or uninvestigated, it's a shame that we can't do it. Now, Geoffrey and I agree on a lot of things, but we don't quite agree on this point, I should say. But as we know, Geoffrey can be a bit soft on corruption on it.
Never heard him accused of that one before.
Well, a bit soft, I said. He's pretty good. But, there are a couple of areas that are covered, for example, in the New South Wales legislation. So collusive tendering by third parties or fraud in application for licence, permits or other authorities, or dishonestly obtaining or benefiting from the payment of public funds for private advantage, or defrauding the public revenue on a really serious or massive scale. Now, those things arguably aren't covered by this legislation. And I know that, and Geoffrey would say that the definition does extend to contractors, but as I say, I think there's a wider area here that's not covered. And it is a shame. And I don't think that the government's going to budge on this. Right from the start, they've just said, well, we'll leave it to the police. But I don't think leaving it to the police is, for the reasons I've given, I don't think it's satisfactory.
Now, Anthony, can I just pick up on that point? Because it's often something that people ask about. What powers is it that the Integrity Commission will have that police wouldn't normally have at their disposal that makes integrity commissions better suited to this kind of work?
Well, I suppose you'd begin by saying, and Geoffrey would be the best one to explain this, that there's a wealth of investigative technique and experience that an anti-corruption commission has that is simply not shared by bodies such as the Australian Federal Police. They are terrific at uncovering drug importations and so on, but this is not an area where they have extensive experience, and they don't have extensive number of personnel or resources devoted to it, whereas an anti-corruption commission does. But in addition to that, and in addition to all of the very significant surveillance and warrant issues, warrant controls that an anti-corruption commission has, it has the power to compel people to answer questions that it may incriminate them. And that's not something the police can do. As we know, when the police ask a question of you as a suspect, you can simply refuse to answer it. But you cannot do that in the context of an anti-corruption commission. There is a trade-off, of course. That evidence can't be used against you if you have made an admission in civil or criminal proceedings. But the power is there, and it's used very powerfully by an experienced anti-corruption commission, and it gets to the bottom of what's going on. It's a power that's shared with royal commissions often. It's a power that some of our crime commissions have in the various states. And anyone who's been involved with those bodies knows that it is a power that has very, very great element of success in uncovering the truth.
Okay. Look, thank you for that. While we're talking about jurisdiction, someone has put into the chat a question about jurisdiction. Russell Smith has asked about the serious systemic requirement. And he's asking, can investigations be conducted into non-serious systemic conduct? And I might, Stephen, ask your view on whether that would be possible under the bill.
No, if it's not serious or systemic, then the NAC will not have a right to investigate it, but nor should they. Something that is not systemic, a once-off incident or a trivial incident, should be really of no consequence to the Commission. If you can have a single incident that's important, in which case it should go to the police if necessary. But you have to have a limit to, there are going to be tens of thousands of complaints that are going to come into this new Commission, and it's got to have the ability there to put to one side matters that you can think of as being not sufficient to justify investigation. Can I just answer one chat question, which is, does the holding of a public hearing prevent criminal proceedings afterwards? And the answer to that, of course, is no. In the criminal proceedings that come afterwards, you cannot use material that has been obtained from someone in the course of hearings by the Commission. That will not be available to be used, but you still have a right to bring criminal prosecutions, although it may be necessary to delay them to ensure that a jury is not infected by knowledge of what has happened in the hearing. It's taken place in a number of matters which have been investigated in Victoria, and there have been, after some delay, successful prosecutions occurring.
Okay, thank you. So Geoffrey, look, I'm going to turn to you now and try to help us benefit from your experience as former counsel assisting ICAC in New South Wales, because obviously you're going to have a real sense of how what is provided for legislatively actually plays out in the work of an integrity commission. And so the provisions I'm interested in asking you about in this context is the provisions relating to legal professional privilege. So does this bill propose to abrogate legal professional privilege? Is that abrogation appropriate? What are any problems you see with these provisions relating to legal professional privilege?
Do you mind me saying I've got better experience than just ICAC, because I've also been counsel assisting at a range of inquiries, some of which permit the abrogation of the legal professional privilege and others which don't. And so I can tell you that if they don't. It'll just, it stops the inquiry dead. Now, for example, inquiries conducted under the Local Government Act or of that kind. You do not know how important it is that you be able to look behind legal professional privilege for the purposes of getting to the truth. Best example I can think of is actually an inquiry in which I was involved, which was conducted by David Jackson into the affairs of James Hardy. And all of that otherwise would have been protected by legal professional privilege. Now, in this legislation, there are two parts to it, which I see as being a little inconsistent, maybe in conflict. The first is that the legislation is quite good. It gets rid of the legal professional privilege in general. And that would allow the Commission to look at matters. Quite often people go, by the way, when they're organising their corrupt affairs, they go to their lawyers, partly to get the privilege, but also partly to get legal advice. Now, it's a good thing that this legislation has abrogated that blanket protection, but then it kind of reinstates it, unfortunately. It brings it back in so that it says that in terms of allocating private and public hearings, that any part of the evidence which would stand in breach of the legal professional privilege must be conducted in private. Now, in practice, that would have meant that during the obit inquiries, when we got to that awesome moment in the inquiry, when the solicitor was in the box, who had file notes where the obits were telling him, we've got to act swiftly because this is going to become public knowledge in only a couple of weeks, we would have had to have stopped the inquiry and gone into a private session. So that would have meant A, a disruption to the hearing, B, a delay, C, the public would never have found out about it. You know what else? It's a problem because if you conduct that kind of a hearing, there'll be other people who are represented in the hearing who'll say, hold on, I need to know this because otherwise I'm prejudiced. So you're going to get all sorts of spin-off litigation as a result of that idea that you must, that's the word that was used, must hold any occasion when legal professional privilege evidence is being exposed, you must conduct that in private. It's a mistake. I'm going to write my own letter to the Attorney General's Department to point out that they're making a mistake. That's how strongly I feel about it.
So can I ask you, Geoffrey, previously we spoke about one really easy amendment, just being striking through the exceptional circumstances requirement. Is there a very simple amendment that could be made to the bill to fix what you're worried about?
Yes, you need to cross out the word must and replace it with the word may.
Seems an easy solution indeed. Let's hope that it is accepted. Okay, thank you. Look, I've just seen one question pop up in the chat that preempts something that I was going to ask myself, but let's ask it now after we've been speaking about jurisdiction. So this question comes from Chris Gehrig, who's asking whether any of our eminent panellists can give us an example of the sort of inquiries that they'd like to see the NAC undertake and or also take to a public hearing. So Stephen, I might start with you. An example of the sort of inquiry that you'd like to see the NAC undertake, say it might be a complaint in relation to sports frauds or something similar.
Before you answer that, I think the underlying question, which is a beauty, is this. There's a difference between undertaking an investigation and conducting a public hearing. So I think you've got to divide it into those two parts, but excuse me.
Let me try the answer in this way. Pork barrelling is something about which there was enormous complaint in relation to the last coalition government, and very, very large sums of money were spent there. Now, it's certainly not going to be clear if the NAC wants to examine either some of the spending by the last government or by this government, whether any particular case of it could be regarded as a matter of exceptional circumstances. Now, indeed, if at the start of the sports frauds, someone had gone to a body like the NAC and said, we've heard that the coalition has given 45,000 to to X body, and we think there wasn't a reasonable justification for it, immediately, I should have thought, the body would have said, well, I can't say at the moment that that's an exceptional circumstance, and I can't even say that it's necessarily serious. Now, that's the sort of problem that the exceptional circumstances difficulty raises and will continue to raise, although I should have thought that from what we've seen of the Jersey report in Sydney, where the Sydney body examined very carefully pork barrelling and arrived at the view that you have to establish where there are competing motives, that the improper one was the dominant motive to justify a finding of impropriety, and one would have thought also to justify the holding of an investigation, possibly in public. But that's a matter which will be very difficult for this new body to decide when it's first asked to investigate something of this kind.
Although I think, as Geoffrey's pointed out, just the preliminary question about the way in which the Commission will embark upon an investigation, it's going to get a lot of complaints, as Stephen said. And if one of them related to the sports rorts type situation, I imagine that what would happen is there'd be very preliminary investigations into it. And as more and more facts emerged at that preliminary stage, and no doubt there'd be a need to decide whether it was likely to involve possible corruption and whether that might be regarded as serious or systemic. I mean, at that point, there'd be no question about holding a public hearing. I mean, it's very early on in the investigatory process. And I suppose once the Commission makes up its mind, it's going to have a look at the sort of pork barrelling type activities in that particular fund, then it would eventually organise some private hearings and hear from people on a private basis. And that might take quite a time. And then after those private hearings had been exhausted, the Commission would then have to sit back and consider whether now they thought there was, in fact, a very real prospect of serious corruption being, involved. And at that point, they would then have to consider whether it was in the public interest to hold a public hearing. And if the definition remains as it is now, they would have to consider whether exceptional circumstances existed. So I think that's the way it would unfold in a practical way. What do you think, Geoffrey?
I think you're exactly right. The standard sort of complaint which arrives at New South Wales ICAC is the local council is corrupt because my neighbour has got their patio extended. Now, those sorts of matters are dismissed very readily at a first assessment stage. Something like sports rorts or any pork barrelling complaint would be assessed at first to see whether or not there was something wrong with it. And that, of course, can mean that the compulsive powers of the Commission are invoked to get the access to the documents, which we can't get. And so they can have a look at it. If there's nothing to it, well, they can close the inquiry. It never becomes public that they ever opened it. Anyway, you're quite right in the way that you described it would unfold.
But just to add to that, in relation to the sports rorts, it was only after a very long period of thousands of hours by the Auditor General that he was able to arrive at the conclusions which his report produced.
That's exactly right too. And so these sorts of things will be very expensive and difficult for the NAC to do. That's one of the reasons why Anthony's quite right when he spoke of the specialist investigative skills which are developed in these kinds of organisations. I hope as the federal or overarching agency, the NAC will be able to attract people, top people from the other state and territory-based organisations. Forensic accountants, that's the way of the world.
So we were speaking as part of this response, I think, Anthony, you referred to receiving thousands of complaints. Under the proposed legislation, is anybody going to be able to make a complaint? Can the Commission also act on its own initiative?
Yes, it's very broad. That's one of the great things about it. You might recall under the former government's model, there was really no ability for private whistleblowers to come forward and lodge complaints, and the own initiative investigation concept was very, very limited indeed. So this is the very opposite of that. The Act unfortunately doesn't spell out the own power initiative. I think it might have been better if it had, but nevertheless, the expression that's involved here, that it can effectively receive complaints and information from anywhere, would be sufficient, I think, for it to act on its own initiative. So all of that's great. That's really a good part of it. That's the sort of stuff that's given Geoffrey a real glow. He shared with us earlier on.
This might be one of those areas, as you said, it is a sufficiently wide power, but there might be some refining to do around how it's actually expressed in the legislation to ensure that it's abundantly clear.
Yes, it looks reasonably clear, but it would be better if it spelt it out in precise terms, that it had that own initiative power.
There has been in the last few days some concern in the media around the protections that the bill proposes to provide for journalists. And while it's I think clear from section 31 that a journalist and their employer can't be compelled to provide information that would disclose or potentially compromise an informant's identity, it looks like an officer of the Commission could seek to obtain a search warrant to get access to precisely that information. So I wanted to ask you, Geoffrey, what you think about those provisions, and if warrants are able to be issued for such material by a magistrate or a justice of the peace, is that sufficient, or in these cases, should those warrants be required to be issued by a judge?
Yeah, there's a few questions in there. The first one is the most difficult. What on earth is a journalist? When you talk about journalists these days, you've got a lot of people who never went to university and who are putting themselves out there as journalists on the basis that they've got a blog. So at one end, you've got people with a degree, and at the other end, you've got people who just call themselves a journalist. I'm not deprecating that latter group, by the way. They do a lot of good work. Well, the point I'm trying to make is that there's no easy definition. Now, if we take it from there, Section 31 seems to me to be, or to legislate in an ample protection. The journalist's employer cannot be required to reveal their source. That is a fantastic thing for journalists. As for the production of documents under a warrant, I can't see what the harm is, because again, if documents are obtained, collected under a warrant, before they're able to be used, they've got to be subjected to a further test, which is obviously relevance, but also will take into account those sort of privacy concerns which are reflected in Section 31 of protecting the source, the journalist's source. So I would have thought that there's little to worry about. It kind of strikes me as strange that the people who are very worried about this aspect are journalists. The people who are very worried about reputational damage are the politicians themselves. There's all these sort of bleating groups who are really promoting self-interest at the end. Your final part of the question, Catherine, was about who should be allowed to issue such warrants. There is a good system in place, and it's working at the moment for ASIC, ACCC, all sorts of bodies, that they be given access, or sorry, the AFP itself, be given access to premises and be allowed to search and seize on the word of a warrant issued by a magistrate, people with a certain judicial office, not the top office. It's working so well so far, I wouldn't want to see this organisation being required to depart from that. I think that answers all of your questions, but I do wish to rebut something that Anthony said earlier. I think that glow is whiskey induced rather than anything to do with this legislation.
Catherine, there are three chat questions that I can answer briefly. The bottom one by Debbie Smith I do not think Section 813 restricts court paralleling investigations. As to the previous one by Chris Geary, a referral from the Audit Office might activate a complaint in the event of pork barrelling, but it would be a matter of the discretion of the Commissioner as to whether it was pursued or not. And the previous one is an anonymous attendee is concerned about our conflict of interest, that we are there really simply to praise the activities of integrity bodies and not to criticize, and we have a serious conflict of interest in that. Well, now that's the first thing, is that's not entirely right. All of us, I think, have seriously criticised the New South Wales ICAC for the Cuneen investigation. What was alleged in that place was neither serious nor systemic from the outset, and that was a serious mistake on the part of ICAC, that carrying out that investigation. But insofar as other criticism of the Sydney ICAC is concerned, I would urge you, the anonymous attendee, to look at the reports of the inspector. One of the important things that a body, and the NAC will have one, is in addition to a parliamentary oversight committee, an inspector to look carefully at the activities of the NAC in future and integrity bodies in the past. And those inspectors' reports will sometimes contain comments which are seriously critical, and each of those have to be looked at by those people who are looking to set up this body, trying to ensure that any mistakes that have been shown are not repeated in the body that is now about to be set up by the Parliament. I can assure you that we think very seriously about analysis that ends up being critical of these bodies.
Look, thank you for that, Stephen. And I would note too that all three of you have always advocated for appropriate oversight of the Federal Commission's work, and that we see part of what your advocacy has been in the inclusion of the inspector in the NAC bill, and also the inclusion of a parliamentary oversight committee. And in fact, I think you might have the view on that committee that it's not actually going to be strong enough. We want to see some amendment there in order to bolster that committee. So Geoffrey, perhaps you could talk to us about that proposed parliamentary joint committee that will have this oversight function in relation to the NAC.
I'll just add something to what Stephen said. Unlike the anonymous attendee, each of us has had the courage to put our names against the points we're making. Anyway, moving on. The Parliamentary Oversight Committee comprises 12 people, and on the face of us, it sounds really, really good. 6 upper house, 6 lower house, 6 from the government, 4 from the opposition, whoever that may be at any time in the future, and 2 from the cross benches. Now, that sounds quite good because that's giving it a degree of balance that often these standing committees don't have. But there's a problem. There's a very specific provision. I think it's clause 173 of the bill. It says that the chair of the committee will be appointed by the government and the chair of the committee will be given a casting vote. So because it's split down the middle, that effectively hands control of the committee straight back to the government of the day. Now, today that's the Labor Party, and they may not wish to part with that power, but they've got to bear in mind they won't be there forever. And the control of that committee could be very, very, very important. My guess is it could be a better thing to say that it'll rotate or it'll be drawn from a hat. But I just don't like the idea that you set up something which looks balanced and then you effectively hand control back to yourself. So it's good, it's not good enough.
Not good enough. And does anyone have any views on the functions of that commission, say, for example, in relation to the requirement that it make recommendations on budget and finances of the commission? Now, it's just required to make recommendations. Of course, the minister can disregard those recommendations if he or she sees fit. So do you think that there needs to be some bolstering of those provisions relating to the committee's functions?
Yes, well, I think that we all believe that a better funding mechanism would be an independent funding body, but we don't have that, unfortunately, and it's not proposed. But as to this one, well, I think one improvement that could be made, I don't know whether Stephen agrees with me or Geoffrey, but I think that if the minister's not going to agree with the recommendations that are made, he should at the very least be required to give reasons for disagreeing with the recommendations that come out of the committee. Transparency, again, we want to know why seriously made recommendations are not being adopted. We don't have that transparency. It becomes, again, a threat to integrity. I mean, the basic problem with agencies around the states has been the withdrawal of funding from time to time, which has sometimes been seen to be aligned with the fact that the anti-corruption body's having a look at politicians and the way they're behaving themselves in and out of Parliament. And that threatens integrity. So transparency at all costs, I think.
And what you're proposing here seems like a very reasonable middle ground, because you're not asking for a limitation on ministerial discretion. You're just asking for a statement of reasons in the case that there's a deviation from a recommendation.
Why is the recommendation not accepted?
Yeah, it seems like an eminently reasonable suggestion. The other aspect of the proposed bill that I wanted to ask you all about is the Commission's power to make findings and to report. So we might start with you on that, Geoffrey. Do you think that this proposed Commission is going to have the adequate power to make findings and report on those findings?
Yeah, it seems to me as though it's reasonably conventional in that respect. I must say I've had a little bit of trouble working my way through the maze, which leads to the issue of a final report. And I was worried at first that there seemed to be an impediment to the Commission being able to issue its own report in the sense that it could be handed to the Parliament. The Parliament would then make the decision as to whether to publish or not. But it seemed to be supplemented by a power ultimately resting with the Commission to issue the report in any event. But they don't do anything briefly. There's 220 pages in the legislation. There's 300 pages in the explanatory memorandum. I've had a little bit of trouble working my way through it. As best I can tell, it seems conventional.
Okay. And Stephen and Anthony, would you agree with that assessment?
Well, there seems to be a distinction between public reports following a public hearing and the publication of reports where there has been no public hearing. I think the issue that arises is one of timing, really, where there's been a public hearing. The requirement for a prompt public report to Parliament is there, but that promptness seems to be missing in the case of a report where there's been no public hearing. The other possible problem really arises from the requirement that in the latter case that people be given an opportunity to respond to a possible finding against them. That raises the spectre of what's been happening in Victoria. Stephen will know more about this than I do, but there have been inordinate delays with IBAC publishing reports, and there have been occasions simply because the litigants in question appear to take advantage of the legislation to protract the finalisation of the report, and that justice delayed is justice denied.
I think I have worked my way through that part of the Act to try and see what it was trying to do. And like you, Anthony, I was troubled by it when I first saw it because I thought it might lead to the problems that they do have in Victoria. But actually, on reflection, I think that it's okay. I think that the provision is one where you only need to give the adverse or potentially adversely affected party a right of response. But that in New South Wales, for example, or at the Police Integrity Commission, or at LEC as it's now known, is done by counsel assisting providing a copy of his or her written submissions to the person. In other words, it's not a formal statement from the Commission, And it's certainly not, as they require in Victoria, a provision of the draft report which the Commission is presently minded to hand down. That's where the disaster comes in Victoria, because when that's handed down, there have been all sorts of applications to prevent it being handed down. I think probably this bill does, when you consider the way it's expressed, probably does handle it the way that I've suggested, which would be good.
Stephen, would you like to comment on this at all in light of the Victorian experience?
I think one of the problems is that the Sandon matter, which is taking a very long time to be dealt with, has been very seriously held up because applications have been made to court, and the court process has been clogged as a result of COVID. And there is at present no provision, no, as far as I know, no court arrangement to give precedence or urgency to court matters involving the ICAC. And they are simply taking their place in a much clogged court list. And that is what's holding up the resolution of the ICAC report. And that is something which I think in the future would have to be dealt with. And certainly under this NAC legislation.
Okay.
One other short matter, I didn't before include in the supervision of the activities of MAC that of course it will be under the jurisdiction of the federal court, and in the event of the NAC misbehaving, there will certainly be the opportunity for seeking an appropriate action from the federal court.
Okay.
So you've really got three protections, haven't you? You've got, first of all, where you've got public hearing, well, it's really four. Where you've got a public hearing, you've got the public can see what's happening. They can form judgments about what's happening. Then you've got the inspector, then the Joint Parliamentary Committee, and you've got the federal court. So there's plenty of protections and plenty of oversights there. And I'd like to just say one other thing. I'm still fretting a little bit over what Stephen said about the possible conflicts we three might have. I don't believe we have any conflicts at all. And I've always been really quite disturbed by the fact that there is so much unfounded and erroneous material published about the activities of state and territory ICACs. Of course, they're not perfect. And of course, sometimes the mark will be overstepped. And of course, there's always a need to keep our eye on reform and to make sure that the integrity procedures are better followed. All that being true, there's a great deal of inaccurate, ill-founded and dishonest material published intending to discredit the whole notion of the public control of integrity in Australian life. And I very much resent it. And I simply point out that if people were better informed, they would understand things and not the way those enemies of integrity depict the situation in Australia.
And can I add to that, that at the very same time that our last Prime Minister was in court making an exhibition I thought disgraceful, describing the ICAC as a kangaroo court and in a variety of other ways, and he was certainly not going to introduce it into the federal parliament. At the very same time, the then Premier, Dominic Perrottet, was appearing on a Sky News program being asked, was the ICAC a kangaroo court, and replying that certainly was not, that it did excellent work, that it was a very valuable body, which provided a lot of very helpful information and warning to the government, and in other words, certainly was not a kangaroo court.
Yes. Yeah, yes, indeed. Well, we've got a few minutes left, and we're going to use those few minutes to circle back to the start of the discussion, which is the fact that we talked last Wednesday, Geoffrey, about your comments, that it was a grand and golden day for the country. And so in respect of this, we've had one of our audience members ask if the bill passes without amendment, Do you think the Commission will ultimately be effective in its role? And I'm hoping that as we finish up, each of you could perhaps give us your views on this.
100% yes. If it goes through in its current form, this is still a great and golden occasion. It's a really fantastic thing. You know, you've got 3 people here who are interested in the issue, who are saying how it can be improved. But what we're saying is also contestable. This is a great tribute, by the way, to the Attorney General's Department and also to Mr. Dreyfus. They've got this thing through rapidly and it's a superb piece of drafting. Overall, yes.
So yes from Geoffrey Watson. Stephen Charles.
Yes, if the legislation passes through in its present form, it's still a tremendous advance and very much in the interests of the community. I think it will still uncover corruption. It will still be enormously to the advantage of the Australian community. It will still, I hope, strongly reverse the slide in Australia's position on Transparency's Communities Perceptions Index and bring us back up again. It could act a little bit better, but it will still be a tremendous advantage.
Anthony Whealy, finally to you. Do you share those views?
I do. I think that it is a great piece of legislation, and credit must go to the Attorney General for his persistence in bringing this through, and for people like Helen Haynes, who's battled through the last Parliament. She must feel very happy about it too. Yes, look, I think it can still work for all the matters we criticise, and in particular the public hearings concern. I think it would still work and can still be made to work. And I think it'll be a great force for improvement of integrity in Australian life.
So it is indeed a momentous occasion, introduction of this legislation, and we are now so close finally to the establishment of a National Integrity Commission in the form of the National Anti-Corruption Commission. We have Chris Gehrig asking, how do I get a job with the NAC? Well, Chris, the Attorney General has promised an open merit-based process, and of course you need to meet the eligibility criteria for appointment, so do have a look at those. Thank you everybody for joining us for this conversation on the strength and some of the areas for refining of the National Anti-Corruption Commission Bill. Thank you to you, Geoffrey Watson, to you, Stephen Charles, and to you, Anthony Whealy. And for those of you who are not yet subscribed to our newsletter, please do subscribe so that you can receive invitations to future events also. Thank you very much.
Thank you, Catherine.